In the previous section, we explored a seller's obligation to disclose all known encumbrances affecting a property, such as liens, easements, or other recorded restrictions. Now, we will examine what happens once those encumbrances are discovered, specifically, how liens are cleared or satisfied during escrow to ensure that the property can transfer to the buyer with clear and marketable title. The process of clearing liens is a critical step in Arizona real estate transactions and represents the intersection of law, title procedures, and escrow coordination. When a property is placed under contract, one of the first steps in the escrow process is the preparation of a preliminary title report, sometimes referred to as a title commitment. This report lists all recorded liens, encumbrances, and exceptions that appear against the property. The escrow officer and title company work together to confirm the property's legal status and to identify any issues that must be resolved prior to closing. The goal is to ensure that by the time the deed is recorded in the buyer's name, the title is free of any undisclosed or unsatisfied claims. Understanding clear title and escrow's role under ARS, paragraph 6 or 841, and ARS, paragraph 33, 801 at SEQ, Arizona law mandates that all liens and encumbrances be satisfied, released, or subordinated before the transfer of ownership, unless otherwise agreed upon by both parties. The escrow officer acts as a neutral third party, following written instructions from both buyer and seller to facilitate the payoff and release of any debts attached to the property. For instance, when a seller has a mortgage loan, the escrow company will request a beneficiary's demand statement from the lender. This document specifies the exact amount needed to pay off the loan in full, including principal, interest, and any fees. On the day of closing, escrow uses the seller's proceeds to pay the lender directly and then records a deed of release and reconveyance to remove the lien from title. This ensures that the buyer receives the property free of that obligation. Common types of liens cleared during escrow. The most frequent liens encountered during escrow include mortgage or deed of trust liens. These are voluntary liens placed by lenders. Escrow pays off the loan in full, and the lender provides a reconveyance deed to release the lien. Property tax liens. If delinquent taxes exist, escrow pays the county treasurer using seller proceeds to bring taxes current. The county then removes the lien automatically. HOA assessment liens. The Homeowners Association provides a payoff statement detailing unpaid dues, assessments, or fees. Escrow pays the HOA before recording. Mechanics or judgment liens. These may require additional documentation, such as a release signed by the lien holder or a satisfaction filed with the recorder's office. Example scenario. Consider a property in Gilbert being sold by a homeowner, Alex. The preliminary title report reveals 3 liens: a mortgage lien, an unpaid property tax lien, and a mechanics lien filed by a roofing company. The escrow officer obtains payoff statements for each. On closing day, the mortgage and property tax liens are paid using proceeds from the sale. For the mechanics lien, escrow contacts the roofer, who agrees to accept payment in full in exchange for signing a lien release form. Once recorded, the lien is officially cleared from title, and the buyer receives the property with clear ownership rights. Subordination and partial releases. Sometimes a lien does not need to be fully removed, but rather subordinated, meaning it is recorded as a lower priority lien behind another. For example, if a seller refinances a mortgage, the lender may require existing liens to subordinate to preserve its first position. Similarly, when only part of a property is sold, as in a large parcel subdivision, lien holders may issue partial releases for the portions sold, maintaining their security interest on the remaining land. Handling complicated liens. Not all liens can be easily paid off. Some, such as IRS tax liens or judgment liens involving multiple creditors, may require court authorization or negotiation. Escrow may need to obtain a release of judgment or certificate of discharge from the IRS or court before title can be cleared. This can delay closing, but is necessary to avoid future disputes. In rare cases, if a lien holder cannot be located or refuses to release a lien, the parties may proceed through quiet title action under ARS, Paragraph 12-01, a court process used to establish ownership and remove invalid liens. This remedy ensures marketable title when administrative resolution is not possible. Timing and coordination. The clearing of liens is usually finalized on the day of closing. Escrow holds all required funds in trust and disperses payments immediately after recording the new deed. Once the title company confirms that all releases have been properly recorded, it issues the final title policy, guaranteeing the buyer against any undisclosed or unresolved liens. Case example, in Re Estate of Bone, 2021. In this Arizona case, the court reaffirmed the importance of verifying and satisfying liens before transferring property in probate or standard transactions. The case involved an estate sale where the personal representative failed to clear a judgment lien before closing, resulting in a buyer's claim for damages. The court held that escrow and title professionals have a duty to ensure liens are properly resolved before title transfer. Discussion: why must liens and encumbrances be cleared before a property transfers ownership? Answer: because liens are legal claims on the property that can prevent clear title from passing to the buyer and may create future liability or foreclosure risk. What document provides the escrow officer with the exact amount needed to pay off an existing mortgage or deed of trust? Answer: the beneficiary's demand statement provided by the lender specifies the full payoff amount for lien satisfaction. What legal remedy can be used to remove an invalid or unresponsive lien holder's claim when all other options have failed? Answer: a quiet title action under Arizona law may be filed to establish clear ownership and remove invalid liens. Review summary. Clearing liens and encumbrances during escrow is a vital part of the closing process in Arizona real estate transactions. Escrow officers, acting as neutral fiduciaries, coordinate payoffs, obtain releases, and ensure that all recorded liens, such as mortgages, taxes, HOA assessments, and judgments, are satisfied before the deed is recorded in the buyer's name. Under ARS, Paragraph 33-801 et SAQ, lenders must issue reconveyances upon full payment, while tax and judgment liens must be resolved or subordinated to deliver clear title. In some cases, a quiet title action may be required to remove unresolved encumbrances. Proper lien clearance protects all parties involved, ensures title insurance can be issued without exceptions, and fulfills legal duties outlined in Arizona law and commissioner's rules.